A lot of attention has been paid recently to patents, with Nintendo appearing to file a flurry of new patents to ring in the new year, raising their total to well over 8,000 patents. Certainly, there are some interesting ones to look at, including something that appears similar in nature to a Mario 35 style game, with others seeming to give insight into controllers and graphical quality for the forthcoming Switch successor. But this video is about digging into Nintendo's relationship with patents. When do they use them and when do they not? How do Nintendo balance security and secrecy with their filings? What are the risks and complexities of managing patents? And to what extent are filings of new patents indications of forthcoming announcements? And how far do they just show something that might be in Nintendo's thoughts for the distant future? If you've ever wondered how seriously to take a Nintendo patent announcement, settle in for this Nintendo Forecast deep dive. First of all, let's be clear, Nintendo files patents all the time, chiefly from Japan, but also from other regional offices. Remember, they have NERD in France and Nintendo Technology Development in America. Small wonder they have a huge and ever-growing research and development team. Yoshiaki Koizumi has talked about how, when developing the Nintendo Switch, there was a treasure trove of existing ideas that they were able to draw from, and while some didn't work, they still had their contribution to make. For example, the magnetic Joy-Con were not secure enough back then, but they did like the click sound it made, so much that they eventually engineered the Joy-Con rails to match it. Then again, this one, for what appears to be a mobile phone-style Nintendogs, has yet to eventuate and ultimately may not. So I guess we need to understand what the relationship is between a patent being filed and the probability of it being used in a game or device. And Nintendo sometimes do collaborative patents. For example, this one concerning the processing of game data with multiple players involved was patented jointly with the Pokémon Company. And it's not a new thing for these patents to surface. For example, when the Nintendo Museum opened, much was made of Nintendo's clay shooter toy from 1974, but Gunpei Yokoi's original patent application is still filed in Australia's system, though the patent in this case has long since expired. This documentation, which seems to have been produced on a typewriter, is a quaint insight, therefore, into times gone by. Broadly, we would expect the decision of when to patent and when to stay quiet to come down to quite specific legal considerations. As Satoru Iwata explained, there is a big difference between studying a product and announcing what it is and when we will release it. I am afraid to say that the history of entertainment is also the history of imitation. A great idea will promptly be copied unless protected through patents. At the same time, it is really important for our business to positively surprise people. Will you be surprised by our completed product if we told you how it is surprising 3 years in advance? Therefore, we basically disclose information on our products as late as possible. We believe this is the best approach for the entertainment products we are developing. On the other hand, patents are important protections, with Iwata himself noting in a separate response that an increasing number of lawsuits were being brought against Nintendo for patent infringement violations. For example, Nintendo did eventually prevail in a lawsuit filed by Tomita Technologies over the 3D technology used in the Nintendo 3DS. This means that registering patents promptly is an important legal tool for defending lawsuits, as well as filing them, as they have done in their recent litigation against Pocket Pair over Palworld. And acquiring patents can be really important to their business. On yet another occasion, Iwata noted, even though we do not have any concrete plans today, this was in relation to mergers and acquisitions, if we encounter a great technology or patent that could give us an edge for future challenges, Nintendo may be able to exercise the option of a merger and acquisition, even though we have hardly done so in the past. When that one technology or one patent is going to be the decisive factor for our future, we want to be able to exercise our option to take it. Indeed, Naoki Mizutani, a director on Nintendo's audit committee from 2012 until his retirement a few years ago, was an expert in patent law and had run his own firm, Mizutani Law and Patent Office. But while Nintendo wants to protect their specific initiatives, just patenting everything in sight may not be their best first choice. Nintendo's contracts will, I have no doubt, contain some very strictly Ninja-enforced confidentiality requirements, and while it is theoretically possible that one of their trusted research and development crew could jump ship and try to patent something that is not their invention, the legal obstacles to such a move would be formidable. As long as Nintendo have non-disclosure agreements, don't do public demonstrations, and don't discuss their inventions, then they don't immediately need to rush something to the patent office. There's also a practical reason not to apply, which is that if for some reason the patent was rejected, as does sometimes happen, then Nintendo will find that they have just communicated their hard-fought-for innovation to the whole world. Not good from their point of view. Amy Van Zandt of Oric, a legal firm specializing in tech, has a blog which shows the complexities at play in balancing secrecy with patent protection. She writes, under US patent law, the patentee is granted a monopoly on his or her invention for a prescribed period of time, generally between 17 to 20 years, in exchange for sharing the details of the invention with the public. The public obtains the full use and benefit of the patented innovations upon the expiration of the patent term. Any information disclosed in an issued patent, by definition, is published and therefore cannot qualify for trade secret protection. United States patent applications are typically published 18 months from the filing date. However, if the invention that is the subject of the patent application is not the subject of a foreign patent application, something that rarely applies to Nintendo if ever, the patentee can file a non-publication request. This means that the application will be maintained as secret throughout the application process, which can sometimes span up to a decade. The inventor can thus maintain trade secret protection over the invention during the patenting process and make the decision on whether to forego that status only once the patent examiner has decided whether to allow the patent to issue. Inventors have sometimes tried to thread the needle between trade secret and patent protection by failing to disclose elements of the invention in the patent application and specification. In Pike versus Texas EMC Management LLC, EMC Management sued Pike for trade secret misappropriation. Pike countered that the information that EMC contended Pike misappropriated is the subject of an EMC patent application and therefore could not be a trade secret. However, EMC explained that it purposely excluded certain information from the patent application in order to maintain it as a trade secret. The Texas Appellate Court agreed with EMC and rejected Pike's argument that EMC's trade secret claims failed as a matter of law. While that tactic worked to preserve the information at issue as trade secret, inventors may risk invalidating a patent by admitting to withholding information from a patent application. So, if Nintendo have come up with something that they may wish to use and to show, they're going to need to get a patent filed. It doesn't necessarily mean they're ready to release a product, just that it's no longer as tightly held and secretive as it once was. For example, if they do product testing, or if they brief collaborators or contractors or manufacturing partners or sound out third-party software development teams, under all these cases it will be prudent to have patents filed. Sure, they have their non-disclosure agreements, but Nintendo is very much a belt and braces company, and I'm sure with regard to their tech innovations, they will not want their unmentionables exposed. In these cases, trips to the patent offices are required. And yes, I did say offices because there are many, many different patent territories across the world. This is why Nintendo aren't going to rush every crazy madcap idea that crosses the mind of a developer over to their law department to get the paperwork filed. Lawyers' cost and making sure that patents are respected in all the major territories Nintendo operate in, let alone the many territories that Nintendo would like to operate in, and let alone the many territories which, in extremis, could rip off the idea and create cheaper parallel imports into the territories in which you're selling. Yeah, that's not going to come cheap. It's not that the individual patent costs are ruinously expensive. Anybody can patent something. It's $100 Australian to file a provisional application, for example. But preparing the paperwork, ensuring the language is airtight, and ensuring that people are keeping on top of all the different global obstacles and potentially liaising with the assessors is a different matter entirely. And so this needs to take place at scale, and Nintendo will need to manage their patents exceptionally carefully. Of course, international agreements do make things somewhat easier. Applications can be made under the Patent Cooperation Treaty, which allows for a single international application to be used to apply for a patent in multiple countries. The PCT, or Patent Cooperation Treaty, is administered by the World Intellectual Property Organization, or WIPO for short. Over 150 countries are signatories of the agreement. It's not quite as simple as it sounds, as all of these territories will have specific local requirements. So Nintendo still need to put in the paperwork for all those different countries, but it at least makes their life slightly easier. There are some countries outside the PCT, notably for Nintendo, Taiwan, and Argentina, where the company still does business. And good lawyers can also overcome obstacles and arguments. Sean Lynch of Lynch LLP states that the quality of USPTO examiners is extremely variable, and sometimes you get an examiner that just doesn't budge. In other instances, examiners can uncover prior art that is just too difficult to overcome. There are many reasons why patent applications might not ever mature to issued patents, but picking a good attorney is the best thing a company can do to improve their odds. He estimates a few $1,000s for provision applications and similar amounts for design patents, which might sound cheap by Nintendo standards, but scaled up across all the countries they're operating in and across all the patents they're maintaining, and in the legal fees and the standing costs of having legal advisors on staff, and you can see that there is an awful lot at stake. Still, while patent law is different in different territories, the principles remain the same. From a US perspective, there are three types of patent. Utility patents covering how a product functions and is manufactured, a design patent covering how the product looks, and most bizarrely a plant patent for new plants, such as unique varieties of almond trees or chrysanthemums. I wouldn't put it past Nintendo to produce the first horticulturally developed video game console one of these days, but we can pretty much assume that most of their patents are utility-based, with perhaps a few focused on design. In order for a patent to be granted, patents must be either a machine, a manufacturing approach, a process, or a composition of matter, i.e. some kind of original chemical compound. It also needs to be novel, so nobody has done it before, and also not anything that is so obvious that it doesn't really need stating. And although I noted that patents have been filed for a long time, the specific regulations do change over time. For example, in January 2019, the US Patent and Trademark Offices relaxed some of their laws related to video games with respect to patent eligibility, which might lead to us seeing a slightly higher incidence of patent filing from video game companies going forward. I'm not sure it's likely to be very obvious for Nintendo though, since they operate internationally anyway, and certainly looking back, they seem to have a very healthy backlog of applications through the decades. In fact, Nintendo has a page on their website dedicated to identifying the patents that they are currently using just in their hardware, and I fully expect that when the Switch 2 is revealed, they are going to want to update their website with a comprehensive list of the patents that they filed to defend any infringements on their hard-earned research discoveries. With a reveal surely being imminent, it makes sense right now that we're likely to see those patents surface. In theory, Nintendo have some grace time, but Nintendo operates internationally and not all countries have the same arrangements. In many territories such as the US, South Korea, Canada and Australia, there is a 1-year grace period from the point of public disclosure to the filing of the patent. In Japan, it's just 6 months. However, in most European countries, this does not exist outside of very specific situations. So basically, by the time a product is announced, it's probably too late to be sure that you can patent it. That's why there is an optimal time to file a patent, and that's a few weeks before you plan to go live. Enough time that you know the paperwork has been registered safely in all territories, but not so much time that it becomes market-sensitive information. Clearly, the opaque wording of most of these patents does help slightly to disguise what they are actually talking about, but equally Nintendo can't be so vague that they open themselves up to the kind of legal challenge that we saw in Pike v. Texas EMC Management. The patents for the original Nintendo Switch were mostly filed in June to August of 2016. The original Switch, of course, was launched in March but revealed in October of 2016. Key patents for Ring Fit Adventure were logged in April and May 2019 when the game was announced at the beginning of September 2019, although of course the game released in October, and it's perfectly possible that Nintendo wanted these patents in place earlier so they had the flexibility to announce earlier if they so desired. April and May, after all, would be just ahead of E3. They don't always operate in advance, though. Pokeball Plus appears to have had applications filed in April 2019, nearly a year after the product was announced. I assume that they felt a little more comfortable in the case of the Pokeball Plus that other companies were not likely to see the inherent appeal of a controller shaped like a ball to catch Pokemon, and so they probably could afford to wait on the application. After all, they would still own the concept of a Pokeball, so it's only the very specific mechanics piggybacking off that concept that they would need to pin down legally. Another example of this is the Joy-Con wheel. While the Joy-Con patents were put in advance, the Joy-Con wheel followed quite a bit later. And then there are cases that are a little bit ambiguous. For example, we saw some Tears of the Kingdom mechanics in the Zelda 2021 trailer, including what turned out to be the Ascend ability, but at the time it was difficult to tell exactly what it was. However, in August of 2023, Nintendo did file patents for concepts clearly linked to Ascend and other abilities, and then showcased much more freely for the September 2023 presentation of Tears of the Kingdom. Anything substantial that's showcased, and they're going to want to lock down their patents right now. Look, none of this should be revelatory. We know Nintendo is announcing Switch 2 by March at the latest, and so seeing a flurry of patents shouldn't really affect our expectations for the timing all that much. If anything, this seems a little later than some of the patents for the original Switch compared to the reveal of the system, some of which were applied for 3 months before the reveal trailer. But then again, the Switch had a lot more original concepts to it than it appears the more iterative Switch 2 is likely to have, so Nintendo presumably need less lead time to get all their legal ducks in a shooting row. We might also expect to see some further game patents ahead of current announcements. I've already discussed a Super Mario Bros. 35 sequel because it seems like such low-hanging fruit, and new patents do nothing to dissuade me of this likelihood, but there's a decent chance that we could see unique aspects of 3D Mario, Mario Kart, and other new games patented, and perhaps the lack of noise around these suggests that they may remain quiet on the specifics of the new games for a while yet. After all, seeing a clip of a graphically awesome set of karts ricocheting around a course is not the same as tipping the hand of Nintendo's newest cunning crochet kart mechanic. That said, the overwhelming majority of Nintendo's patents pertain to technology, so I would not expect to be able to define too much about the games ahead of time in any event. The history of Nintendo's patents is massive spikes around new hardware. This chart from December 2024 shows that the last year was exceptionally quiet for patents, but don't be misled. Because patents can take 18 months to file, recent numbers always look lower. But look to the spikes around previous console reveals in 2011, 2012 and 2017 to see that Nintendo will probably be putting in quite a few applications in the months ahead. For more on Nintendo forecasting, these videos on screen have you covered. Thank you to everyone who shares, likes, comments, subscribes and even checks out the Patreon below. And I look forward to seeing you next time for another Nintendo forecast.